All right, we're back on the record in case number 26-90103. Go ahead, counsel.
Thank you, Your Honor. Just some very brief redirects. I realize we're short on time here. Mr. Weinstein, I'd like to pull up the organizational chart that you were shown earlier in your testimony. Can we do that?
Okay. Okay.
Mr. Immer.
All right. Now you can be the presenter, Mr. Immer.
Now, Mr. Weinstein, this section right here is what you were discussing with counsel to Amazon earlier. Is that correct?
Correct.
But the entity is much bigger than this section of it. Is that also correct?
When you say entity, you mean Saks Global?
Yes.
Yes, much bigger.
So, Mr. Immer, let's zoom out a bit. Thank you. Now, Mr. Weinstein, is this a representation of the organizational structure for the global debtors?
Yes.
Okay.
And a few non-debtors, but yes.
Thank you. Mr. Immer, let's zoom back in, I think, to where you had it, actually. I may have prematurely asked you to zoom out. Thank you. I want to ask you about this box, SFA Holdings, Inc., Tennessee. Do you see that box?
Yes.
What is your understanding of what that entity is?
Well, that is the entity that a lot of the operating company rolls up under.
And is it your understanding that that company is an ultimate corporate parent of Holdco 2?
Yes.
Do you know who Paul Aronson and Bill Tracy are?
I do. They're the two current independent directors of Saks Global.
Do you know if Mr. Tracy or Mr. Aronson are directors at SFA Holdings, Inc.?
I believe they are.
Do you know if Mr. Aronson and Mr. Tracy made decisions with respect to Holdco 2?
They would have been part of that decision as well.
And did those decisions include the filing of the Chapter 11 petition?
Yes.
And did those...
To be clear, when I referred to the independent members of the board earlier in the cross-examination, those are the two gentlemen I was referring to.
Thank you. And did those decisions include the decision to enter into the DIP financing?
I'm sorry, to enter into?
The DIP financing?
Yes.
You've been asked questions earlier about how much debt Holdco 2 would be required to repay under the DIP. Do you recall that testimony?
Yes.
And those questions focus on this structure, Holdco 2, correct?
Correct.
Now, are there other assets in the enterprise that could potentially be used to satisfy the DIP?
There are lots of other assets that could be used to satisfy the DIP. Yes, there are those claims at Holdco 2, but that doesn't mean that at the end of the day that other assets won't be used to address the ultimate resolution of the DIP.
And are these other assets, do they serve as collateral for the DIP?
Yes.
So is it accurate to suggest that Holdco 2's assets are the only collateral for the DIP?
They're not the only collateral for the DIP.
I believe you've testified about this a couple times, but I just want to ask again to make sure your testimony is clear. Was there any other executable proposal for DIP financing without liens on Holdco 2's assets?
No, there was only one other executable DIP financing proposal. As I mentioned, the likelihood of success of implementing that was significantly lower than the proposal we're moving forward with, and that was the only other proposal that had the same treatment of Holdco 2.
And my last question, Mr. Weinstein, in view of time, is what would happen if the DIP financing is not approved today?
if the DIP financing is not approved today, there would very likely be irreparable harm to the debtors. We need to pay bills. There's really two aspects to that. And I think I alluded to this earlier. There's our ability to pay bills as they come due, which is obviously a requirement under Chapter 11, as well as, the critical trade payments, which would address pre-petition, which is also important, very important. But there's also the perception of Saks Global, the company understandably has been much maligned over the last many months and has lost credibility with the brand partners and other important partners. And securing financing today would communicate an extraordinarily strong message to that community that we are going to be here, we are going to continue to do business, and we are going to be somebody you want to do business with. And for our employees, it's critically important. As you can imagine, irrespective of anything you say in meetings and encourage people to feel good, once you actually secure the financing, people feel a lot better. And so it's really important to get that messaging out today.
And do you think the company could continue to operate without approval of the DIP financing?
No, they cannot.
I have no further questions, Your Honor.
All right. Any recross? All right. Thank you, Mr. Weinstein. You may call your next witness.
Thank you, Your Honor. I will turn the podium over to my colleague, Stuart Lombardi. Oh, I'm sorry, Your Honor. Just brief clarification. One point of Mr. Weinstein's testimony was imprecise. He referred to the Bradley firm having been hired by 12 East 49th Street. With respect to the reorganization, the Chapter 11 case, it's not entirely accurate. The Bradley firm is conflict counsel to assist solely with reviewing the operating lease amendment. So I just wanted to clarify the scope of their representation.
Understood.
Thank you.
Thank you.
Good evening, Your Honor. Stuart Lombardi, Wilkie, Farr, and Gallagher, proposed counsel to the Global Debtors.
Good afternoon.
Thank you, Your Honor. I know it's late in Houston, and I suspect you're not the only one in the courtroom giving us your time. We really, really appreciate your time. As you know, there's a lot on the line here. A centuries-old icon of retail, thousands of jobs. We really appreciate you giving us the chance to put on our case.
Understood.
The Global Debtors call James H. Baird to the stand.
All right, Mr. Baird, would you raise your right hand, sir? You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you. Go ahead, Mr. Lombardi.
Are you aware, Mr. Baird, that Amazon has argued that Holdco 2 either does not need DIP financing or, if needed, should procure smaller, more reasonable DIP financing?
I heard that.
What's your reaction to that statement?
The entities in the flagship part of the structure need dollars to service rent obligations and the flagship needs. So you can sort of say they don't need a DIP, but they need dollars, and dollars in bankruptcy come with liens and associated costs.
What about the concept of a smaller Holdco 2 only DIP? Why didn't Holdco 2 enter into a smaller Holdco 2 only DIP?
Couple reasons. One, it wasn't on offer, and then additionally, I think it would have jeopardized the DIP we have. I don't think that the existing lenders would have wanted to lend into that structure.
Right. Jeopardize the DIP we have. What do you mean by that?
Means we have $1 billion coming into the company during the pendency of the case from existing lenders to the company. I don't know that they would have been as forthcoming with those dollars in that dip, in that structure if Holdco 2 was leaned up by somebody else.
Did the debtors have a financing proposal from anyone to finance the global debtors minus Holdco 2?
Minus the flagship? No. The flagship part of the structure? No. Everybody wanted liens on the flagship part of the structure.
What would have happened to the debtors as an operation without financing for the other boxes, the non-flagship boxes?
I mean, I think you heard Mark talk about it, right? I think you'd run afoul of being able to pay bills and obligations as they come due almost immediately, which in a retailer winds, pushes you ever closer to liquidation in any given day or week thereafter.
So even though a dip like that wasn't on the table, a dip that carved out the flagship boxes, let's go back to talking about a flagship-only dip. At any point in your dip marketing process, did any prospective lender express a willingness to extend the dip only to Holdco 2?
No, I mean, again, we've heard about it. Amazon, the Friday before a presumed Sunday filing, said that they would be willing to consider a Holdco 2 dip, but there were no actual proposals from them prior to that, and no one else was prepared to do it.
Now, at some point in time prior to that Friday before the filing, did the debtors approach Amazon seeking financing?
There's a paragraph in my DIP declaration, I believe it's paragraph 15, that refers to someone generically. That was Amazon. We spent months with Amazon going through all range of options on flagship, on inventory collateral, on the whole company, whether financing or potential sales of assets, and nothing bore fruit.
When you say nothing bore fruit, did Amazon make any actionable proposals to you?
No proposals.
About how long did those discussions last?
I think mid-November till the end of December, ballpark. They slowed down when it became clear that we weren't sort of getting equal engagement on the other side of the table. So we started emphasizing others.
When you say you weren't getting equal engagement, what do you mean by that?
Means in our discussions with Amazon, they took in a lot of information and they didn't provide a lot of solutions. And so we had to focus on where we could find solutions.
Now, when you say that Amazon didn't offer solutions, how about ideas? Did you make any proposals to Amazon on behalf of the debtors?
Yeah, I don't know on paper proposals, but, the beginning of the process in the middle of November and even into December, I mean, at one point we were having daily calls to sort of brainstorm solutions. Again, they tapered off. We'd have a long meeting to brainstorm solutions. So we were desperately searching for liquidity from every nook and cranny we could find it, and we had hours and hours and hours of conversations with Amazon about all range of possibilities.
Could you give the court an example of something in that range of possibilities?
Yeah, we asked if they wanted to finance, effectively a FILO piece on the ABL. So behind the ABL loan, we asked if they wanted to finance the flagship assets. We asked if they wanted to buy the flagship assets. We considered a range of options. Those are several that come to mind.
Did Amazon move forward with any of those ideas?
No.
At any point in time before the Friday before the debtors filed for bankruptcy, did Amazon offer to provide DIP financing to Holdco 2?
No.
Did Amazon offer to provide DIP financing to any of the global debtor boxes?
No.
Let's talk a little more about that Friday letter. Were you present in the room when Mr. Weinstein was cross-examined about a January 9th letter from Amazon's counsel to the Global Debtors Council?
Yes.
Did you view the concept of a potential dip floated in that letter as actionable?
No.
Why not?
So we were miles down the road with both the existing lenders and a potential third-party non-consensual priming dip that is detailed in my declaration as well. We were documenting both. I think we're moving closer and closer with the existing lenders every hour, and we were actually aiming at a filing on Sunday night. We wound up. So the letter came 2 days before we were actually aiming to file. We wound up extending the filing in order to finalize papering the transaction. But I don't think you're getting that dip done in 2 days. And again, the history that we'd had in the discussions didn't indicate that it was going to bear fruit.
I've asked the witness for cross, Your Honor.
All right. Anyone wish to cross-examine Mr. Baird?
Yes, Your Honor. Chris Harris for Amazon.
Go ahead, Mr. Harris.
Thank you, Your Honor. You were in the room for the earlier testimony, so I don't need to go over these terms again, right, sir?
I'll try to remember. Yep.
If you don't understand, please trying to save some time. So, just to confirm, PJT was retained in May 2025, right?
That was a previous engagement, yes.
Okay. And that was in connection with the liability management transaction in the summer of 25, right?
Yeah, you're breaking up for me a little bit, but yes, that was with the liability management transaction.
Okay. And at the time, did Sachs's advisors, including PJT, advise the company that they thought that would address the company's liquidity needs?
That's not what we do. No, we heard from the company an estimate of the dollars that they thought they need, and that was on the order of magnitude of $600 million, and we spent time trying to figure out how to raise it.
Okay, so the company thought the LME transaction would provide the liquidity it needed, right, sir?
Yes, that's my understanding.
Okay. And then very quick wrong, right, sir?
That happened to be the case, yes.
Okay. And in fact, the company has continued to miss its projections, updated projections throughout 2025, right, sir?
I don't recall sitting here.
You don't recall that the company has missed its updated projections, is that right?
I don't know what you mean by updated projections. The company has not been doing well, if that's your question.
Okay. And both PJT and BRG have been involved since early 2025, right, sir?
We were not involved in early 2025, no. We got involved for the liability management transaction towards sort of the middle of 2025, I think.
Okay. And what entity has retained PJT?
I mean, I think a lot of them. I don't know. I'd have to go look. We provide advice to the debtors and affiliates.
So you don't know if you've been retained by Hoto too?
I believe we have.
Okay. And PJT led the company's efforts to secure DIP financing, right?
We were one of the advisors that solicited DIP financing, yes.
Okay, and that process started in mid-December 2025, right?
No, well, we started educating people before then, for sure.
Well, but the actual outreach to potential lenders was in mid-December 2025, right? So that's when it started.
maybe for a dip specifically, but again, we were talking to potential financing sources about other things well in advance of that.
But outreach about a potential dip specifically was just a few weeks ago, right, sir?
I can't recall the exact date sitting here, but sure.
Okay. And who from Saks participated in the process of attempting to procure dip financing?
Who from Saks? I mean, the management team was involved in all different ways. I'm not sure I understand the question, though.
Okay. Well, let me ask you this way. Was there anyone, whether from Saks or any of the advisors to Saks, who was acting just on behalf of Holdco 2 in the dip process?
I'm not sure.
Can you identify any person for the court?
I said I'm not sure.
Okay. The PJT was authorized to seek a Holdco 2 only dip, right? That was within the scope of its mandate, right, sir?
We were authorized to seek dip financing in the best possible form for the debtor entities.
And PJT never solicited a Holdco 2 only dip, right?
We solicited dips in any possible form that people would give them to us.
Okay, that's not my question. Did you ever ask any potential lender whether they would provide a Holdco 2 only dip?
I did not call everybody and ask about every box on this page, no, if that's your question. I asked people if they would finance the company and how they would do it on the best possible terms to get us the most possible proceeds to finance the case.
You never asked anyone if they provide a Holdco 2 only dip, right, sir?
I'm not sure if it was for a dip or pre-bankruptcy conversations, but we certainly asked Amazon if they would finance the flagship under any circumstances.
So you asked Amazon, sir, you asked Amazon if they would buy the flagship. You never asked Amazon to provide a loan for Holdco 2 only, did you, sir?
We asked Amazon if they would finance the flagship. I didn't say Holdco 2 specifically, no, but we asked if they would want to put financing at the flagship.
Okay. You never asked Amazon or any Holdco 2 only creditor whether it would provide an unsecured Holdco 2 only dip, right?
Again, not specifically to Holdco 2. We asked a number of parties if they would provide junior financing.
Mm-hmm. So you never asked about a dip size just for the cash needs of Holdco 2, right? The CMBS monthly payments of under $5 million. You never asked anyone if they'd be willing to provide a Holdco 2 only dip size to that amount, right, sir?
We did not ask that specific question, no.
Okay. And you never asked anyone, including Amazon, whether they provided on an unsecured basis, did you?
When we spoke to Amazon, we said, would you provide financing for the flagship on any day? Like, it wasn't specific to secured or unsecured or otherwise. It was, would you finance the flagship entities?
The debtors have other assets besides the flagship that, could be and are being used to secure dip financing, right? Like Neiman Marcus and Bergdorf Goodman, right, sir?
Yep.
Okay. And did the debtors ask any third-party lenders whether they'd be willing to provide a dip of any size secured by assets other than the flagship property?
We asked if anybody would be willing to finance pieces of the company or the whole. We tried that out of court, and that didn't land. And so then we started soliciting dips in whatever form people would lend to the company.
So my question is, when you were soliciting dips, did you ever ask any of the third parties if they provide a non-flagship dip? Did you ever ask that question?
Yes, we asked people to finance the company excluding the flagship, and the answer was no. We asked the existing lenders if they would do it without the flagship, and they said no.
Did you ask third-party lenders?
Yes.
Okay. Now, I believe you said both entities both the ad hoc group and third-party lenders said they would not provide a DIP unless it was secured by the flagship property. Is that right?
Yeah, they were both the same structure, and they wouldn't change the structure.
Okay. So the ad hoc group was only willing to do a DIP if they could obtain the value at the flagship property, right, sir?
Yes, that's my understanding.
The ad hoc group has liens on the operating SACS assets, right, sir?
Among others, yes.
So they apparently didn't think that the DIP increased the value of those operating assets enough to justify making a DIP just based on those operating assets, right, sir?
Objection, Your Honor. Calls for speculation, state of mind of a third party.
Sustained.
Yeah.
Well,
I don't know
I sustained the objection.
Okay. Sorry.
okay. You said a little on your direct about expenses that the Holdco 2 entity needs that would be funded by the DIP. Do you recall that, sir?
No, I said somebody had to pay rent on the flagship.
I see. Are you aware of any other material expenses at Holdco 2 or its subsidiaries besides the...
Our system will end this conference in 5 minutes. To extend this call for 1 hour, please enter the moderator PIN now.
$6 million per month?
I don't.
Your conference has been extended for 60 minutes.
Subsidiaries will end up using any of the cash from the interim DIP, right, sir?
Don't.
Okay.
I believe the company needs to make the payments down to those boxes, so I would assume that they need that money.
Well, SACS needs the money to make its pay its obligations, right, sir?
Under the lease, yeah.
Okay. Now, you heard Mr. Weinstein testify that the SACS lease payment was just reduced. You heard that testimony, right, sir?
I did hear that.
In fact, it sounds like it was been just reduced down to match the amount of the CMBS interest payments, right, sir?
I don't recall.
Okay. Well, if in fact the lease payments were reduced from $7.7 million down to $4.6 million, that'd be about a 40% reduction, right, sir?
Okay. I trust your math.
Okay. Now, you've done discounted cash flows before, right, sir?
I have done discounted cash flows before.
Okay. So if I'm valuing the value of the property encumbered by the lease and the lease payments go down by 40%, the value of the encumbered property probably goes down by approximately that amount, right, sir?
Objection, Your Honor. Improper, hypothetical, and lacks foundation. Hasn't been established that that's why any lease reduction was done.
Well, I don't think that's the question. I think the question is, if you reduce the cash flow by 40%, does that impact value? I think that's the thrust of the question. I think Mr. Baird can answer that.
I did not value the real estate. I don't know what the payments were, what the expectations of future payments were. I don't know what the cash flows are today or yesterday. In general, if you lower the cash flow of an enterprise, then the value could go down. But there's a million other factors that could come into that.
So have you seen any analyses, quantitative analyses, of the value of the property encumbered by the SACS lease at its new reduced value?
I don't know what you mean by new reduced value. I've not seen analyses of the value of the property as of today, if that's what you're asking.
Do you know whether the new ground lease payment is more or less what a replacement tenant would pay?
I don't.
Okay. Would you agree Holdco 2 is essentially a holding company for real estate, right?
Not my area of expertise, but if you say so.
Well, it's essentially a landlord, right?
Again, if you say so.
Okay. Would you agree that through this DIP, Holdco 2 is essentially guaranteeing a loan to its tenant?
I don't know what you mean.
Well, you realize the Saks operating entity is its tenant, right? Or the tenant of its subsidiary, right, sir?
Saks owns the boxes in this chain. Saks is pledging those boxes to a loan that it's taking, if that's what you're saying.
Yeah, well, I'm trying to analyze just from the benefit of Holdco 2, as if it were actually an independent company with independent fiduciary. So from that perspective, it's a landlord being asked to guarantee a loan to its tenant, right, sir?
A loan to its tenant. I'm not following, but the chain is owned by Saks, right? So it's an asset of the Saks Global Enterprises. So it's pledging an asset to a loan that it's taking out.
Did anyone run a quantitative analysis just on behalf of Holdco 2 to determine whether it was net beneficial to Holdco 2 to guarantee a $2.6 million loan to a bankrupt tenant?
I don't know.
In your experience, have you ever seen a landlord guarantee a third party's loan to its tenant?
I don't know.
Okay. Has PJT or any other advisor analyzed the likelihood that Holdco 2's guarantee will be called?
I wouldn't know what that means. I'm not sure what you're asking.
You don't know what the guarantee is?
The likelihood that it would be called?
Yeah. What's the likelihood that, in fact, Holdco 2 is going to have to make a payment on account of the guarantee? Do you know, sir?
That's perfect.
I think we were on too long. Just dial back in. Sorry.
One of the outgoing responses.
That was funny.
Mr. Barrett, are you still on the line?
Yeah, we're back. Sorry about that. Distracted by cameras blowing out.
Probably.
We're back.
Your Honor, this is Mr. We haven't got our video up yet, but I don't want to waste your time. I could questions and just assume the video looks great. Okay. So
I forgot the question. I'm sorry.
My question was, has anyone performed an analysis on behalf of Holdco 2 indicating how likely it is that it will have to perform under the guarantee, make payments under the guarantee?
Right. I don't know.
Okay. All right. Can you just imagine with me that Holdco 2 was an actually independent company like Vornado or Simon, and they came to you and said their tenant wanted for Vornado to guarantee a loan to that tenant? In that instance, you want to know the percentage likelihood the guarantee would get called, right?
I mean, it's not that crazy if you think about it, because those guys benefit from having that tenant in their door. So I might not be tracking the question.
No, I think you are, sir. I think you are. I mean, you'd want to know, for instance, whether the current lease of that tenant is above or below market, right, sir?
I'd want to know that they can pay the lease.
Well, if in fact Vornado could get more from having the lease canceled, they wouldn't really have an interest to guarantee their tenant's loan, right, sir?
I mean, there's a lot that goes into that question. You don't just cancel leases because you can get a different price in the market.
You want to know at least by how much the current lease is above market, if it is, right, sir?
I lost the chain. In terms of what analysis?
Say Vornado was the owner of the flagship property. They would want to know whether Saks is paying above or below market, and if above, they want to know how much above market, right, sir?
In order to do what?
In order to determine whether they provide a $2.6 billion guarantee to Saks. Vornado would want to know whether the Saks lease is above market or not. They'd want to know how much above market it is. They'd want to know how likely the guarantee is going to get called. They'd want to know all that, right, sir?
I think you'd want to know a lot of things, but I think most important is that your tenant's going to pay the rent.
Mm-hmm. You'd also want to know if the tenant is going to pay the rent through the life of the lease, right?
You're going to want to know that they're going to pay the rent for the foreseeable future. Yeah.
Mm-hmm. Okay. And no one here has done an analysis to determine whether the new lease is above or below market, and whether it's so much above market to justify imposing a $2.6 billion liability on HOCO 2. Isn't that right, sir?
I'm not sure what the question was. I didn't track the question.
Do you recall anyone doing an analysis to determine whether the new Saks lease is sufficiently above market to justify imposing a $2.6 billion liability on HOCO 2?
I'm not sure if anybody. I don't know what analysis exists or doesn't on the lease payments.
Okay. A few more questions. Did the debtors ever send a proposal to the ad hoc group that did not include the guarantee at HOCO 2 or its subsidiaries?
I don't recall if we sent one on paper, but we certainly discussed alternatives with them that would have included not leaning up the flagship.
Okay. Just a couple more questions, sir. Can you tell me today another interim DIP that imposes $1.5 billion of DIP obligations on an entity that doesn't need a DIP?
I think the entity needs cash flow, and the entity is in bankruptcy, and in order for people to provide capital to bankrupt enterprises, they usually want liens, and that often takes the form of DIP status.
Mm-hmm. Can you tell me another DIP where the debtors rolled up onto one entity almost $1.4 billion of pre-petition debt that sits at other debtors?
I don't know that that's the case.
Okay. Nothing further. Thank you.
Thank you. All right. Anyone else wish to cross-examine Mr. Baird?
This is Jim Ducaille from Sidley. No, Your Honor, I think Mr. Harris covered the couple questions I was going to ask.
All right. Anyone else? All right. Any redirect?
No redirect, Your Honor.
All right. Thank you, Mr. Baird.
Hi, Your Honor. This is Jessica Graper. For the record, we just wanted to flag that the utilities order was uploaded. I believe it's docket number 189.
All right. Just give me a minute.
Thank you.
Your Honor, this is Caroline Reckler. While we're waiting to join, could you try to reset perhaps the go-to meeting, because we can't get back on. We've tried with computers, phones, everything.
All right. Why don't we let's just take a 5-minute recess, and I will get off a GoToMeeting, and then we can come back on. So
thank you.
We'll be back at 10:15.
Thank you, Your Honor.